So the Supreme Court recently granted review to the next big Second Amendment case, and once again it deals with state concealed carry restrictions and laws passed in direct defiance to what the court already said in their 6-3 ruling in Bruen. The court recently has given permission for the Trump administration to participate in the oral arguments, and now the petitioner has submitted their final brief to the Supreme Court arguing why the court should strike down this law. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, you can click on the notification bell and turn on all notifications because that helps to ensure that you get these videos when I release them. I also want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm is an amazing company, pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel, but also they have amazing supplements and apparel. So if maybe you have a New Year's resolution and you're trying to get healthier, maybe you're like me and I'm trying to work out, 4 times a week and get 10,000 steps and do all of that and eat healthier, check them out. You can buy some of their supplements, check them out using the link down below. And if you use that link and you order any supplements, you can get a free 5-pack of protein sticks. Now, as I mentioned in the intro, in this video, we're going to be talking about a 2A case that is set to be decided by the Supreme Court this term. And once again, it deals with state concealed carry restrictions. This case is called Wohlford versus Lopez, and it's a critical case for concealed carry going forward. This ruling by the Supreme Court will either protect that Bruen ruling that they've already issued, or it will open the door for states to continue to place restrictions on concealed carry going forward. Recently, the DOJ and AG Bondi actually stepped up in this case, and they stepped up in support of this challenge, and they call for the Supreme Court to strike down this Hawaii concealed carry restriction. And recently, the Supreme Court granted the administration's request to participate in the upcoming oral arguments, and on top of that, the petitioners have now filed their final brief arguing why the Supreme Court must strike down these concealed carry restrictions. Now, if you're not aware, the Wohlford case is a challenge to Hawaii's new laws on concealed carry that were passed in direct response to Bruen. This law, like other laws, tried to add more restrictions to concealed carry and create this default rule where individuals can carry firearms on private property only if the owner of that property gives you express permission to do so. Plaintiffs, along with 2A organizations, sued the state of Hawaii to strike down this law, and they received a preliminary injunction which helped to temporarily block this law from going into effect. Hawaii then decided to appeal that decision up to the 9th Circuit, and of course the 9th Circuit ruled in their favor. But ultimately that then led this case to seek emergency Supreme Court intervention. So now it's in front of the Supreme Court. And the Supreme Court granted review to this case even though it was on an emergency basis, even though it was an interlocutory issue, and now they will hold oral arguments in this case on January 20th. Now what that means is that the Supreme Court will directly address this whole catch-all property ban that was passed in direct response and defiance of Bruen. And this is not an issue just relevant for Hawaii. There are other states like California, New York, and others who have put in place a very similar concealed carry restriction. Now, one of the critical things that may have led the Supreme Court to take this case on an emergency basis was that prior DOJ brief. And once again, the Trump DOJ is still jumping in to support this 2A effort, and they recently submitted an amicus brief and then official brief on the merits, arguing that the ultimate decision of the Supreme Court should be to strike down these catch-all property bans. The first thing they argue is that Hawaii's affirmative consent rule violated the Second Amendment because it was designed purely to suppress concealed carry within the state. They argue that the law here in question was not aiming to abide by Bruen or the Supreme Court precedent at all. Instead, it has the ultimate goal and true goal of simply frustrating 2A rights. They argue that Hawaii already had protections for their property rights and property owners. They could do things like traditional trespass laws to protect their property, and property owners could always post signs that simply said something like "no guns allowed." But this default ban by the government is not about protecting property rights like the state of Hawaii is claiming, but instead the ultimate goal is to expand upon gun-free zones and make almost everywhere within the state a gun-free zone. Now, after the Trump DOJ submitted that amicus brief, we all anticipated that the Trump DOJ would try to participate in the oral arguments on behalf of the pro-2A side, and that's exactly now what has happened. So that's great news, and it would likely be beneficial to have the administration on our side during these arguments. And now this case is kind of heading into the final stages of arguments, and the petitioner here, Wohlford, has filed his final brief to the Supreme Court, arguing why it should finally strike down these concealed carry laws and rule in their favor after the arguments. He argues that at the core of this case, he believes that the Hawaii law here was effectively aimed to wipe out the right to carry, firearms in public, And he argues that that was put in place despite what the Supreme Court already said, in Bruen, and they already stated that clearly your right to carry firearms in public is a right that exists and is protected by the Second Amendment. He argues that Hawaii's law flips the rule upside down by banning carry on nearly all private property open to the public unless the owner gives express permission in advance. He argues that the Supreme Court has already said the Second Amendment protects carrying firearms in public places as part of your everyday life, and because this law directly targets that conduct, Hawaii has to prove that it fits within America's historical tradition of firearms regulations, and he argues in his brief that the state of Hawaii here can simply not meet that burden. He states that history shows people carried firearms in shops, taverns, and public-facing businesses, and it was always the property owner, not the government, who got to decide whether that was allowed. He goes on to state that to justify this ban, Hawaii points out some old trespass laws and anti-poaching laws, but he also states that those laws were about stopping illegal hunting on enclosed land and private land, and not simply about banning lawful carry for self-defense in the public. He then points out that even worse, the state of Hawaii relies on some Reconstruction-era discrimination laws which were designed to disarm newly freed individuals. They argue that using these laws as support is both morally and legally unsound and therefore must be rejected by the Supreme Court. He then concludes by saying that this law put in place by Hawaii was a very deliberate and clear defiance of what happened in Bruen. Essentially, when Hawaii lost its old carry law under Bruen, it just banned nearly every place people could carry, even if they got a permit. He argues that if the Supreme Court does not strike this down, well, then essentially Bruen will be done away with, and states will continue to put in place these, complete bans within the state to make your permit essentially useless, even though Bruen said that you have a right to concealed carry. So this is huge for the Second Amendment movement going forward. This term, the Supreme Court will once again hear a critical Second Amendment case and rule once again on concealed carry restrictions. And the good thing is we have the Trump administration on our side, and the Supreme Court is allowing them the ability to join the arguments on January 20th and also argue in our favor. That is great news, and it will likely also help to push this case to get a positive 2-way ruling. And also, I will note most of the arguments that Hawaii is using to support this law are very unsound and have been rejected by courts in the past. It's going to be very interesting to see, what does the Supreme Court say during those arguments about some of these issues that are raised by Hawaii. I suspect that many of the justices will actually press Hawaii on the fact, that this law was created in direct defiance to Bruen and that the justifications they're using are just simply morally wrong. So that's what's currently happening in this critical concealed carry case that is set to be argued next week. And again, this is going to be a landmark case for the Second Amendment going forward. So as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm or Al Gore's rhythm. It adds fuel to his jet and just tells YouTube that you appreciate this type of 2-way content and it should share it with more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.